So we'll talk about domestic community property based on the full set of facts that we have just set out. So in terms of community property law, we've got the situation, we've got all these facts, and the questions that we have is firstly the basis of what is the basis of Chinese community property rules? Secondly, does Chinese community property law apply to inherited property or property acquired before marriage? And pre and post nuptial agreements legally effective? So I would like to invite Dr. Gong to kick off the session talking about the Chinese community property law issues.
Yeah, so basically for the China community property rules, so for all the assets acquired during a marriage, unless there's an agreement, like a prenuptial or postnuptial agreement stating otherwise, they will be owned jointly by the couple. And the community rule apply to inherited property unless otherwise stated in the will or the gift agreement. But for the property acquired before marriage, the rule of thumb is it shall belong to the person that acquired the assets, but not treated as community property. And for the third question, for pre or post nuptial agreement, generally speaking, they will be legally effective. They will be treated as legally binding unless, for instance, they never entered into marriage, unless it was entered into the agreement under force. But generally speaking, it will be considered as binding and effective.
And does it make a difference that you can have a post-nuptial agreement? So after the celebration of the marriage, is there any difference, or it's basically the same principles being applied?
It's basically the same principle.
And when you do these nuptial agreements, do you have to go to a notary, or does the court have to endorse it? Is there a particular sort of formalities that you need to go through to make them effective?
Yeah, unlike, let's say, the rules in the US, there's a particular procedure. Generally speaking, in China, there's no particular formality. It must be in writing, though.
Right, okay. Okay, I think, Michael, we could probably go on past the questions that we've already answered.
Right, so the next one, Frank, is whether Yin can claim community property rights to property transferred into a trust, and in this particular case, a Hong Kong trust, and also whether Hong Kong trust law provides protections against Chinese community property claim.
Mm-hmm.
And what about the trust's indirect shareholding of the 30% in the Chinese trading company? So in this case, the trust holds a Hong Kong company which holds possibly a WFOE that then holds 30% of assets that are actually situated in China.
All right. So for the first question, can Yin claim community rights to property transfer to a foreign trust? Now, if the lawsuit is initiated in China, the PRC court will not, generally speaking, will not entertain such kind of claim, largely due to the fact that the property or the assets are owned or located overseas. The PRC court, generally speaking, they will not go beyond their jurisdiction to rule, to make rulings over assets outside of China. And for the question number 2, does Hong Kong trust law provide protections against the community property claim?
Don't worry about that one, Frank. Don't worry about that one. I think it's the one with the ownership of the China trading company, because that is within the jurisdiction of China.
Yes, that's a good question. Now, the PRC court, they will treat the trading company as owned by its parent, not treated as if it was owned by the ultimate shareholders.
Right.
So that's why they will, generally speaking, they will respect the current shareholding structure and will not break it down, and by declaring that the assets, because of the ultimate ownership alleged by the other spouse, they will just entertain such claim by asserting, helping, by allowing the spouse to assert rights over the assets located in China under such structure.
Okay.
Right.
So here, what we're looking at is, from a Hong Kong perspective, would there be a recognition of community rights? And would effectively Hong Kong trust law provide protections against that community right? Perhaps later on, Frank, when he joins us again, can talk about the issue when it's in terms of the assets or the shares held in China. But from a Hong Kong perspective, there's no firewall protection against a community claim on the trust. And in fact, all of the international financial centers have not sought to effectively override community property rights when it comes to their firewall protections against forced heirship or against matrimonial sort of discretionary court orders. So from a community right, as long as Hong Kong is satisfied that the matrimonial domicile is China and it confers these sorts of rights to assets that were placed into trust, in other words, the community rights when the assets were transferred into trust, there's no Hong Kong law that will bar that proprietary right being traced into the trust. So the point of that is Hong Kong does have protections, but like a lot of the other international financial centers, it doesn't seek to protect against community rights, because in effect, a community right is a proprietary right. It's not by succession law. It's actually something that you would own by virtue of the marriage. And in this case, Hong Kong, applying common law principles, would look to the matrimonial domicile. And if that provides community, then it would also recognize that insofar as assets that were transferred into trust were cloaked with a community right to them. So that's an important consideration when you're creating trusts, because if you do have a couple from, let's say, a civil law jurisdiction or a jurisdiction that recognizes community, you would effectively need to go through a procedure of at least having the spouse that's not contributing the assets consenting to the contribution of the asset by one of the spouses, because what you're looking at is jointly held property effectively.
Yes, that's right, Zach. And I think that the recent Otto Poon case is perhaps a case in point as well, too, because that was where a married couple, where the husband settled listed company shares into a trust during the marriage, where the beneficiaries were the husband, wife, and the daughter. And when the couple divorced, the wife tried to claim or claw back out half of the interest in the trust, whereas the husband tried to argue that no, that the trust was really for 3 beneficiaries and she should only get a half of the 2/3, not the daughter's share. But in that particular case, the court accepted the wife's claim that she should be entitled to half of the total of the assets that were settled into the trust during the marriage.
Yeah, that's correct.
Firstly, would the US recognize a foreign community property or Chinese community property ownership? So perhaps we'll let John talk about this point.
Sure, thanks, Michael. I think an important thing to recognize or understand from a US perspective, absent a contention, the concept of community property and some type of mandatorily shared interest between spouses is recognized in the United States. A little different than I think what Frank will cover. It's a state by state basis. So we have a federal taxation system. Sitting below that is a state taxation system. But from community property, or as we'll talk about later in the slide, succession planning perspective, those are typically regulated at a state level. So the answer here is yes, the US could recognize that ownership or assignment absent a contention, but that there could be a contention raised on behalf of some member of the family, depending upon where the property is located and which state's rules might differ from the conclusions that are reached in the offshore jurisdiction. There'll be slight differences between movable and immovable property. So for the example we have here, the company shares or other types of bankable or movable property assets, maybe not as likely to enforce the US rules under a contention, but with the landed building, the immovable property, highly likely that there could be a challenge raised under the differing rule in the state jurisdiction. So something to think ahead about, and hopefully there is either a prenuptial agreement, or as we'll talk about coming up in the succession planning side of things, maybe a will to steer clear of the clash of rules that could arise with different jurisdictions.
And John, just on that, is it right that the US would look at the matrimonial domicile of the parties? And here, clearly the matrimonial domicile is China, and they would be sympathetic to the community rights that's established in China in recognition in the US, is that right?
I would say there is a partial deference. So from a recognition of marriage perspective, absolutely. The US, both at the federal and the state level, has the concept of defining marriage as it is defined in the jurisdiction in which the couple are domiciled or resident. So there would be a respect for the fact that there was a marriage. It tends to flow logically that then you give some deference to the laws governing that, but we're adding the complication here of a second residence of the property that's perhaps in contention if there's a challenge raised. So I think in general you're correct, but we need to be careful that there is a bit of a stronger problem that might need to be resolved, because those states where the property is located could have conflicting views on how the property is supposed to be divided.
Right.